Hello, and welcome to the Claremont Review of Books podcast, which is where we discuss in depth some of the richest articles from the latest issue of the Claremont Review of Books. I'm your host, Assistant Editor Spencer Clavin, and my guest today is Professor Amy Wax. Professor Wax is the Robert Mundheim Professor of Law at the University of Pennsylvania Law School, where she teaches remedies, conservative political and legal thought, and social welfare law and policy. She's here today to discuss two articles with us. The first actually is a piece that she wrote for Law and Liberty at lawliberty.org, and that piece is called Woke Lawyering and the Rule of Law Don't Mix. But eventually we'll get back around to talking to her latest CRB article, which is about Supreme Court Justice Ruth Bader Ginsburg. Professor Wax, welcome to the studio. Thanks for being here.
And thank you for having me.
Great. Well, let's leap right in and just talk about this Law and Liberty article to start. You have written in depth here about the ways in which social justice warriors and woke, you might call it woke philosophy, woke religion, are posing a threat both to the philosophy of the legal profession and to the teaching of the legal profession. You write several paragraphs into this piece, you write, "There was a time when all lawyers were trained to respect the traditional adversary culture, to honor their worthy opponents, and to treat them as indispensable players in a fundamentally sound system rather than as evildoers on the side of the devil. Now, those conventions and touchstones are under siege." Could you start out for just a minute by telling me why it is you think that traditional adversary culture in the law is what social justice warriors really can't abide? Why has that been the major target of woke religion?
Well, there are a number of parts to woke progressive ideology, to their dogma and their culture, and some of those are deeply threatening to our traditional adversary process, which has been around for a very long time and is fundamental to the rule of law, to the search for justice and the search for truth, and has served our culture, the Anglo-American tradition of law, extremely well. So what am I talking about here? One hears from proponents of social justice, the champions of oppressed groups, and of course, social justice warriors and woke culture divide the world comprehensively into the oppressed and the oppressors. But one of the ways in which we're supposed to protect oppressed groups, and of course, proliferating complement here, is to shield them from certain arguments, certain statements, certain propositions about the universe that they might deem upsetting or insulting or adversarial to their particular interests, adversative to their particular interests. In addition, they see the rule of law, that is the traditional Anglo-American tradition, as a product of white male hegemony, because historically we know that it has been mainly the doing of white males who were in charge of the legal system and indeed the system of government. So there are elements and there are arguments that are made as part of the proper functioning of our legal system that are considered destructive, harmful, and contrary to the interests of oppressed people. Now, many of the hot button issues that the law deals with are about minority rights. They are about situations and issues that touch on what happens to minorities or underrepresented minorities. Just off the top of my head, of course, we have a lot of litigation surrounding affirmative action. Mm-hmm. And ordinarily, when we argue the merits and demerits of affirmative action, there are facts and positions that are taken that will be critical of affirmative action and will question its benefits. In the woke culture, questioning the benefits of affirmative action is considered harmful, traumatic, and an attack on minorities. So as you can imagine, it's very hard to represent both sides of the issue in those circumstances.
Absolutely. Yes. You mentioned affirmative action. That's something for which I think you, or perhaps let's say racial issues of affirmative action along the line of race, something for which you've received a fair amount of, I hesitate to call it persecution, but negative press. And University of Pennsylvania has made some statements about things that you've said. What's your experience being sort of in the trenches, as it were, with it, teaching law as these developments are unfolding, as things get worse and worse with regards to woke culture? Have you been sort of on the front lines of that, as it were?
Well, I mean, I've been thrust into the front line. Some of the things that I've said in the public forum, and I'm referring specifically now to a blogging hits I did with Glenn Lowry that got me into trouble.
Right.
And I can talk a little bit more about that in detail. But I think more broadly, here's what I would say about it. One, deals honestly with the facts and effects of affirmative action at one's own peril. One may be able to get away with it in certain contexts, being frank about, for example, the racial gaps in achievement that make affirmative action necessary, because of course that's just fundamental. But then at other times, if you talk too candidly about it and start to speculate about the possible causes, that will be deemed unacceptable. So there's a certain element of unpredictability here that makes it especially dangerous to engage these issues in any way but the accepted way, which is to argue that affirmative action is wonderful, it's great, and all virtuous, right-thinking people believe in it. And that is the default position on campus. That is the default position in law schools. So it's a treacherous journey to engage some of these topics. But of course, it's incredibly important because so much of what happens at universities now, so much of what happens in the workplace, at law schools, in K through 12, is imbued and informed by commitments, right, to diversity and to equal outcomes. It's just everywhere. I know a lot of people who teach in medical schools. I have a lot of family members who are academic physicians, and they tell me that this is the most important topic when people are getting together to write a grant or renew a grant or get funding, or even to plan research. They spend the majority of their time obsessing about diversity and inclusion related topics, and secondary is doing the actual science. So it's very hard to avoid these topics. But once again, if you don't have the orthodox opinions, you can easily get into trouble.
Yes, that's a chilling assessment, and it squares with some of what I've heard from friends who teach. I'm glad you mentioned the K through 12 system, because I think this is one of the areas in which this ideology is most ferociously installed, and I've heard other people say that there's simply no pushing back against it without great cost and risk, which always brings me back to this quote from the beginning of Plato's Republic, that when Socrates' friends are trying to get him to come to dinner, he tries to get out of it, and they say, how can you convince us if we won't listen to you? And one of the things that's most chilling about what you're describing here is the self-fulfilling cyclical nature of it. The fact that by shutting down critical discourse, woke ideology essentially reinforces its hold. And I'm wondering if you see any way out of that. What is the remedy to that system? And is there any way to turn back the tide on the kind of ubiquity of this in the academy?
Well, I get asked that question all the time. I go around the country and talk to undergraduates. I talk to citizens groups. In the next week, I'm going to be talking to a citizens group. I talk to parents of children, and they all are really, they're in a quandary. What can we do to push back against this ideology? I think the reason it's hard, one of the reasons is that the woke, ultra progressive elements who control the system and are the most zealous and vigilant about their dogma, they are on some level very ruthless about trying to cancel, punish, penalize, and call out anybody who opposes them. It's particularly tragic, I think, in K through 12, because behind closed doors, parents really, there are many parents who are not on board. They are not on board for woke curriculum, which teaches their children that we have a hideously corrupt and oppressive society, that we ought to be destroying that society, remaking it, totally transforming it. This is what kids are being taught today. And as you can imagine, that's extremely dangerous and ahistorical. And parents just feel powerless to oppose it. So now you've asked me, well, what can we do about it? I haven't really answered the question. I've just reaffirmed that there is a huge problem. It's really a collective action problem. That people just don't want to speak out because the costs of doing so are just tremendous. And the only individuals who are willing to do that are individuals of the highest integrity. I can think of the example of Paul Levy, who was one of the overseers, a big donor to Penn Law. He's perhaps given more money to Penn Law than any other donor. He's endowed a scholarship. He's endowed a conference center. And he stood up and spoke out against the way the law school had treated me, and my dean, Ted Ruger, had treated me, was critical of him, was critical of the president of our university. And it really did cost him to do that. First of all, nobody joined him. And in fact, one of the trustees, who will go nameless, told someone that he should shut the F up and mind his own business. Well, I think when you give tens of millions of dollars to a school, it is your business, but never mind. So really, people will say critical things in private, and I've had many, many people tell me they're not happy with what's going on, but they will not stand up in public. Now, the other group that ought to be standing up, but isn't because they're captured, is tenured professors. I'm not saying tenured professors don't get hurt by speaking out. I'm a tenured professor. There are lots of ways in which they can make your life miserable and penalize you and, of course, shun you and turn you into a pariah. That goes without saying. But it's very hard for them to take your job away. I'm not saying it can't be done. It can be done if the will is there, but it would be costly. But we're not seeing tenured professors speak out either. So the people who have the protections and could say something, they're not doing it. Parents of K through 12 children, or even parents of college students, they're very vulnerable. And the students, of course, are extremely vulnerable. They have no protection. They can get themselves into trouble quite easily in the internet age. Once some kind of horrible label like racist or sexist or white supremacist attaches to you, it's almost impossible to get rid of it. And so I understand why there is so much caution. It's just going to require the kind of courage that, I see is in very, very short supply. I really don't see it happening at all. They see, what happens to someone like me. They think, why would I do that to myself? I understand it.
Yes, no, there is no substitute in the end, I think, for courage. And you're being modest, but you have yourself shown a tremendous amount of courage in this regard. I want to make sure that we spend a little bit of time talking about your essay in the latest CRB, because it's actually interesting, I think, to hold these two essays side by side. So in the latest CRB, the Winter 2020 CRB, which listeners can find by going to ClaremontReviewOfBooks.com, you've got an essay which we ended up titling Notorious. It's about the notorious RBG, Ruth Bader Ginsburg, and her path to the Supreme Court and her tenure on the Supreme Court. And one of the most interesting things I think about this essay is that in some respects, especially in detailing her career up to the Supreme Court, you view Ruth Bader Ginsburg as potentially a proponent of this older system, which woke ideology wants to dismantle. You see her as somebody who, even if conservatives will disagree with her strenuously in a number of areas, somebody who is willing to acknowledge the value of the system, the value of exploring controversial ideas. At one point, you write, on the bench, Ruth Bader Ginsburg displayed her talent for analytical rigor, methodical reasoning, and lawyerly attention to detail. She burnished her reputation as an ideological centrist and temperamental moderate with little taste for dramatic legal gestures, and she forged alliances with a wide range of jurists, including Antonin Scalia, quite famously. And you also then go on to describe the ways in which her legal career was, in some sense, activist, in which she had a specific concern to equalize opportunities and to equalize legal treatment of men and women. And I wondered whether you saw those two things as in tension in any way, whether having an activist bent for RBG was in tension with her belief in the system that you describe, or whether those two things can work together for somebody like her.
Well, that's a very interesting question. First of all, I'm very wary of the term activist because I think it's one of these terms that's been hijacked and turned into a propaganda weapon. So I'd rather not explicate what activist means. I will say this about Ruth Bader Ginsburg. She is in some ways a throwback, or at least for a long time was. I think like any person who's lived a long time in the public eye, she's undergone, or many people anyway, she's undergone something of an evolution.
Mm-hmm.
So, we're talking about a moving target here, but certainly in her early years and up until not long ago, if you look at her work and you read what she says, she is committed to a fairly old-fashioned and conventional idea of what the law standards are and how the legal system should function. She very much worked within the system to advance her project of more robust rights for women. The results were fairly novel in that the courts did kind of wake up and think about women's position, whereas they hadn't before. But they used old legal tools and old legal concepts in a way that was evolved naturally from some of the prior work, some of the prior law that had existed. So, since the Civil War, the Equal Protection Clause has been on the books, right. Hardly a new concept. And the courts have worked steadily to try and refine and define what equal protection means. And Ginsburg's bright idea, and there were other people who were talking about this at the time, and I'm talking now, of course, about the 60s and the 70s, said, wow, equal protection doesn't mention race. There are a lot of different categories of people. Maybe we ought to take equality for women or equal rights for women as seriously as we take equal rights for race. Now, for some people, that was a radical idea. But for other people, it seemed like the natural outgrowth of what had gone before. So I guess what I'm saying is, it depends on how you look at it, whether her project of advancing women's rights was radical or really rather conservative. Now, of course, we have reached a point, and Christopher Caldwell has talked about this, it's on many people's minds, where the meaning of civil rights laws and civil rights concepts like equal protection really has become transformed. I think conventionally it meant the law should be blind to these categories of birth. So a kind of color blindness, a kind of sex blindness, and that we should open the channels of opportunity to people so that they could go as far and as fast as they wanted to. I think now we are in a new era where equal results and equal outcomes are being demanded And that is a truly transformative idea. That is arguably something that, was never understood to be part of the Equal Protection Clause or the enacted civil rights laws or anything like that. Now, Ruth Bader Ginsburg has not really, in a full-throated way, joined this kind of woke demand as such. But, and I talk a little bit about this in my piece, I think she has ideas about men and women that if opportunity is equal, then it will follow naturally that their positions in the world will be similar or equal or the same. In other words, she really thinks there's kind of one model for participation and success. And to my mind, she sees that model as male. And women's reproductive function, women's nature is no obstacle to women achieving everything that men do, stepping into all the roles that men have. I don't see her as wanting to transform those roles, as with difference feminism, or to feminize those roles, or to completely rewrite the rules for society or the rules for the legal system or anything like that. I don't hear her saying that. So she doesn't go straight to equality of results, but I think she has this belief that if the system is functioning properly, even on the old school, that we will get equality of results.
Yeah, no, this brings me right up to my last question for you, because in the end of your piece, you launch into what is probably your most strenuous criticism of Ginsburg, which in some sense is as much a criticism of how Ginsburg has been received and what she's been made into in the public eye as it is of Ginsburg herself. You use this word icon, and you describe how RBG has become a sort of icon for feminists as feminism moves in some sense away from the equity feminism model, which is more focused on equal opportunities, is probably closer to what RBG has actually worked for, and toward a sense that, right, there are no differences between men and women that matter in any way for the outcome. The difference is an outcome between men and women's lives. If you take the reins off, then men and women will have the same aspirations, the same desires, fulfill the same roles at the same level, at a kind of equal percentage. And you say that Ginsburg herself has become a sort of totem of this because she has been so successful in traditionally male-dominated spheres, but at the same time, she's highly irregular, you say, fueled by her own fortunate situation and the insular elite domain she occupies. Ginsburg has failed to confront the real trade-offs that might be entailed in expanding women's rights. She has never stopped to consider that the nature of womanhood and the intricacies of family relations might impede equality of outcomes, or that interchangeable roles for men and women might not be attainable or even desirable for the great majority of people of either sex. Now, you mentioned Christopher Caldwell, and as you say, really since Deneen's The End of, or Why Liberalism Failed, these ideas have been in the air. And one of the most troubling things about Caldwell's argument is that he tends to view the excesses of the post-civil rights movement as inherent in some ways in the logic of the way the civil rights movement proceeded in law and the Civil Rights Amendment. I wonder, do you think the same about Ruth Bader Ginsburg's ideology? Do you think that this kind of swerve toward a more radical kind of pure equality feminism was in some way inherent in the logic of what she was doing and arguing, even if it wasn't expressly stated? Or do you think that somewhere the way that she was turned into an icon, the way that she was basically weaponized as a vision of what all women should be, was that an accident? Was that a kind of deviation from what could have been a more reasonable and equitable idea of feminism?
Well, I like you calling her a totem because she has become a totem or a representative of, interestingly enough, what I think she believes or aspires to. She has fulfilled the very aspiration that she would like to generalize, which is men and women will converge, and they will aspire to the same things, they will achieve the same things, all of that. She has actually managed to do it by dint of her extraordinary ability, her work ethic, her energetic, tireless, her efforts, her very even-tempered personality. She has many, many attributes that have enabled her to do that. And so she achieved about everything that a man could ever wish for. And then she has become the icon for that ideal type. Mm-hmm. So that's, as you restate, that's what I say. But I think that's the problem, in essence, with holding her up as the ideal. She is extraordinary in many, many ways. And at the end of the day, most women do not aspire to be RBG. And that is that a problem? Well, we can admire RBG for everything that she has achieved and yet recognize that she is highly exceptional for women. I go back and question this notion that the male model is the model in all respects for what women should want and what they should aspire to. Now, let me just say as an aside that I think there are pockets of male modelhood that I very much endorse. For example, when it comes to the law, how it should operate, the rigor and the argumentation, the even-handedness, the adversary, the elements of the adversary system, if you want to call that a male model, because obviously it is the product of centuries of male ingenuity and development. Women were not really participating in that system. Then I fully endorse that. I don't think that system needs reform. And if women are going to be lawyers, then they have to learn all of those standards and all of those touchstones. No, I'm talking about something far broader, which is every aspect of social life, in particular family life, the relations between men and women, how children are brought up, how families are constituted. We still have in our society fairly well-defined roles for men and women, different roles in practice, in fact. What women want from family life and from professional life is on average different, at least if we are to credit the choices they make, than what men want. So if part of her vision is to see men and women as taking identical roles in the family, in personal life, at work, in all aspects of existence, if that's what Ruth Bader Ginsburg stands for, then I think she is a problematic model, and even potentially a harmful model for women, because it's at odds with what a lot of women want.
Well, the essay, one more time, is called Notorious. It's in the winter 2020 issue of the Claremont Review of Books, which may already be in your hands if you're listening to this. But if it's not, you can go to ClaremontReviewOfBooks.com and read Amy Wax's wonderful work, as well as a number of other great pieces. Professor Wax, thank you so much for joining us. It's been a pleasure talking to you. Thank you so much for listening to this episode of the Claremont Review of Books podcast. I'm your host, Assistant Editor Spencer Clavin. The podcast is produced by Jake Gannon. The Claremont Review of Books is published by Ryan Williams and edited by Charles Kessler. For more great Claremont content, you can go to www.claremontreviewofbooks.com or www.americanmind.org. See you next time.